On our litigations, DOJ bottom line is that Congress can regulate commerce by forcing people into commerce and then regulating them actually all in the same step. Doing nothing, ladies and gentlemen, is an economic activity that Congress can reach for a combination of a Commerce Clause and necessary and proper clause. And this argument has at least 5 major constitutional consequences, all of which violate both fundamental principles and settled case law. First, as I already said, it eviscerates dual sovereignty. I'm going to spare you from quoting James Madison to that effect, but we all know that states have residual sovereignty that cannot be infringed by Congress. It's often referred to as a police power. Regulating an activity by forcing people to do things not based upon activities they voluntarily engage in, but compelling them to act is the very essence of police power. Another key attribute of police power is that unlike regulation of individuals based upon their activities, it cannot be avoided. And nothing captures this distinction better than the fact that all one has to do when dealing with federal statutes regulating a particular activity or commodity, be it wheat or weed, and more about it later from my colleague Randy, is not to engage in this activity, not to touch that commodity, and you'll be out of a federal regulatory vortex. By contrast, when the state of Massachusetts requires all adults to obtain smallpox vaccinations, there's no opting out. If you're an adult and you happen to be within the borders of Massachusetts, the mandate grabs you. To justify claiming the police power for the federal government, DOJ, of course, argues that inactivity, specifically a failure to acquire a particular good and service, is within the scope of a Commerce Clause as augmented by the necessary and proper clause, so long as that inactivity can be linked to an economic effect. The problem, of course, of this argument in modern economy, every inactivity in the aggregate has some economic consequences. There's no meaningful limiting principle, and everything can be swept under the Commerce Clause. Now, recognizing this problem, at least tacitly, the government in defending ObamaCare is relying more and more on the necessary and proper clause, but they're being a little funky about it. To begin with, the government clearly is creating its own necessity here to justify the application of a clause. But alleged necessity, ladies and gentlemen, is cost shifting, the prospect that some folks would go to emergency rooms, use health care, not pay for it, shifting the cost to others. But why is cost shifting such a huge, palpable problem here? The answer actually is other government regulations that Congress passed as part of ObamaCare. That is very different from a necessary and proper clause as applied in Reich, about which, again, more later on in this panel. DOJ certainly misreads Reich in a standing proposition that Congress may do anything, including reaching inactivity, as a part of a larger regulatory scheme. That is, of course, not the rule of Reich. It's also passing strange to me that Constitution would preclude the imposition of certain legal requirements standing alone, while countenancing readily the imposition of the same requirements if they're packaged as a part of a broader scheme. To put it differently, Congress can pretty much take any step at once as long as it's a big step. Under DOJ's logic, as a matter of fact, Congress should pass very capacious statutes with ambitious policy goals, have them badly drafted as far as the exercise of enumerated powers are concerned, have a regulatory gap, and then presto pronto, you have mandates. In fact, the bigger is the gap, the more is your need for general police power. And at the risk of sounding flippant, I shudder to think how many individual mandates it would take to accomplish the intended purposes of something I call the Happiness and Welfare of All Americans Act of 2011.